What happens if you're a landlord, you take a tenant to court for delinquent rent, the renter agrees to a payment plan in court to get caught up, but never makes the payments under the plan? Well, that's the topic of this video. Hello again, I'm attorney Robert Flessas. I recently received a comment from a viewer who went to court, entered into an agreement with a tenant to make installment payments, but the tenant defaulted on the payment plan. The viewer said that the tenant doesn't want to vacate and can only pay a certain amount towards the arrears that are different than the payment amounts that were agreed to. The viewer asks, when they go back to court, will the judge give the tenant another chance for payment or authorize an eviction? Good question. But first, if you find my videos helpful, please consider subscribing to my channel. I'm building an archive of valuable legal videos on my channel. If you want to comment, please make sure that you tell me the state you're from and make your comments brief and to the point. I answer viewer comments, but remember, my answers and videos are not meant to be legal advice. My videos are intended to educate you on legal issues. With your comments, my answers, and these videos, we're building a community education forum. If you post a good question, I may make a video based upon that question. Well, let's get to the topic of this video. Remember that every jurisdiction has different eviction statutes, and courts have different ways to handle evictions when both the landlord and tenant appear at the first hearing. You should always check your local statutes and court rules. I'm going to speak in general terms here to answer this viewer's question. When a landlord files an eviction, they're looking to remove the tenant from the premises, or they'll work out a payment agreement with the tenant in court so that the tenant can get caught up. The question becomes, though, when the parties appeared in court, was the agreement reduced to writing? Well, it should be. A court agreement is usually referred to as a stipulation between the parties. Just like a lease, the parties are making a promise to each other. When working on a payment agreement with a tenant, the landlord promises not to evict the tenant in exchange for the tenant promising to make the installment payments. I don't know if this viewer entered into an agreement like that because they never said that in their comment. But here's how you properly make an agreement that should withstand scrutiny. Put the caption of the case at the top of the agreement. Then write down the agreement in detail. The agreement needs to state that the landlord will agree to not evict the tenant if the tenant makes installment payments to the landlord. But that's not all. You need to state the amount of each payment and the specific date that each payment is due. You also need to indicate how the payments are going to be delivered to the landlord. For example, by U.S. mail, by personal delivery, by some electronic means, or whichever way you accept rent. Make it clear in the written agreement that if the tenant misses any installment payment, then the landlord can go back to court without any further notice to the tenant and can ask the court to authorize an eviction. Also, make it clear that the landlord can seek damages against the tenant if they default on the agreement. Usually in court, you have to pick a damages date in advance. By inserting that date into the agreement, then you're providing advance notice to the tenant of a damages hearing. If the terms are crystal clear in the agreement, then the document is signed and dated by both the landlord and the tenant. The signed document then should be presented to the court for the judge's signature. With the court's approval, the agreement or the stipulation will become a court order. If the tenant subsequently fails to make an installment payment, then the tenant violated a court order. The agreement has teeth when it's a court order. If an eviction is authorized, then you evict the tenant and go back to court to obtain a judgment against the tenant for your damages on the pre-selected date. Damages can include unpaid rent, your filing fee that you paid to the court, process service fee, and any other authorized costs granted by a court. Now remember, every court handles evictions and stipulations differently. You need to know your local rules. You might even want to consult with a local attorney who regularly deals with evictions regarding the local rules. They'll know the rules. I hope this video was helpful. I'm attorney Robert Flessas. Thanks for watching, and I'll see you in the next video.